Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, what is a special needs trust?
Hey, Emily, thank you for that question. So, a special needs trust, sometimes referred to as a supplemental benefit trust or supplemental needs trust, are discretionary in nature and are established for the sole benefit of a person with a severe and chronic disability. The trust proceeds can be utilized to purchase services that Medicaid does not cover for the disabled person without disqualifying the individual for certain means-tested government benefits like Medicaid, supplemental security income, which is otherwise known as SSI, or Section 8 housing. In order to qualify as a special needs trust, the funds from the trust must only be used for the sole benefit of the beneficiary. This means that the funds from the trust can only be used to pay for the items, products, or services to assist in the care, management, or treatment of the individual's disability and to improve the quality of life for that individual. The general rule under the Medicaid federal statutes is that states are required to include income from trusts in order to determine income eligibility for SSI or Medicaid. Therefore, if a potential Medicaid applicant funds a revocable trust, those assets are considered to be available and accessible to the Medicaid applicant and could jeopardize the applicant's ability to qualify for Medicaid. The special needs trust and special needs pooled trusts are exceptions to the general rule that funds set in trust are countable resources in regard to Medicaid eligibility. If third-party assets are transferred to a common law third-party trust, or if the disabled individual's assets are transferred to an account for a self-settled irrevocable trust set up more than 61 months before an application for Medicaid is filed, then those trust assets can be excluded when considering whether an individual is eligible for Medicaid benefits. A self-settled special needs trust must meet the following requirements. 1, it must be established by a parent, grandparent, legal guardian, or court, or after December 13, 2016, by a competent disabled individual. The second requirement is that it's utilized for the sole benefit of a disabled beneficiary who meets the definition of disabled pursuant to the terms of the Social Security Act and who is under the age of 65. And the third requirement is that it contains first-party assets, meaning the disabled beneficiary's assets. The fourth requirement is that the trust is irrevocable. Next, the trust has to be discretionary, meaning that the disabled beneficiary cannot have any power to assign, encumber, direct, distribute, or appoint funds from the trust. And lastly, the trust documents must contain a reference to the enabling statute, which is the Omnibus Budget Reconciliation Act of 1993, and the beneficiary's status as a disabled individual, as well as the purpose of the trust to preserve eligibility of the beneficiary for public benefits, and that the assets in trust should be used to support, not supplant, eligibility for public benefits. The requirements for a special needs pooled trust are as follows. 1, it has to be established by a parent, grandparent, legal guardian, or court, or after December 13, 2016, by a competent disabled individual. Second, the trust document must contain language that any amount remaining in the disabled beneficiary's account upon death, to the extent not already retained by the trust for the use of other disabled beneficiaries, must be paid over to the state as the first payee. And lastly, there is no age restriction on this type of trust, but federal courts are split as to whether contributions to the trust for a disabled beneficiary that is over the age of 65 may result in an imposition of a transfer penalty. Also, it is usually advisable to retain an economist or life care planner when determining the financial needs of a disabled beneficiary to a special needs trust. A life care planner, usually a nurse or geriatric care manager, can develop a personalized plan of care to address the current and future services and supports of the disabled individual over the course of his or her life. Many different factors determine what type of special needs trust is appropriate in a certain circumstance. For example, the funding sources, funding amounts, and any applicable Medicaid liens are important factors to consider when drafting a special needs trust. Therefore, if you would like to discuss creating a special needs trust, please feel free to give me a call and I'd be happy to help.
Attorney MacDonald is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney MacDonald at LMacdonald@mayalaw.com, and please visit mayalaw.com for more information.